So this is the part they never want you to notice. When Republicans talk about January 6th, they almost never argue the facts anymore. They argue the referee, not did it happen, but were you allowed to investigate it? Because that's the only lane left when the record is ugly and the receipts don't cooperate. And that's what made this exchange so revealing. You've got Reppers Jasmine Crockett basically saying, you're not defending Trump's conduct, you're trying to disqualify the investigation that proved it. Then she turns the spotlight right where Jim Jordan hates it, his own fear, his own contact with the White House, and the reason those phone toll records mattered. It's a classic move. Scream process, so loud nobody talks about the plot. And the most important part, she didn't just go after the rhetoric. She anchored it to the report language, the deposition mention, the toll records, and the courts. Let's watch what happened, and then I'll break down what's really going on here.
Just to be clear, today it seems like the Republicans have not really fought very much about whether or not Trump was guilty or not. In fact, their fight seems to be over whether or not you were authorized to prove their guilt. Do you recall a number of Republican members asking about whether or not your appointment was okay, even though we know that you've testified about the more than 100-year precedent that allowed for your appointment?
I was asked questions about that today, and our position, as we filed in our appeal, is that there was strong support for my appointment, including Supreme Court precedent directly on point.
Thank you so much. Additionally, everybody's been all gingerly here today, but I don't know why we're acting surprised that a man who had close to 90 allegations out of 4 different jurisdictions and ultimately ended up with 34 convictions after a jury was able to hear all the evidence would possibly be committing a criminal act on January 6th. In fact, considering the fact that we are now under the impression that he is violating people's due process rights, he is ignoring court orders, he's starting wars without congressional authority in contradiction to the Constitution. He's enriching himself to the tune of over $1.4 billion. He's shaking down electeds to draw maps that will help him stay in power because the Republicans don't understand that they swore an oath to the Constitution and that we are supposed to do checks and balances. He's also shaking down TV stations to get money. So why are we trying to pretend as if it is out of the realm for this particular man to commit the crime that he committed on January 6th, and frankly, the only reason he ran for president was to make sure that he would not be prosecuted, because I fully believe that you would have put him under the jail based on our long-form conversation that we had. But according to your special counsel report on page 137, it states the department's view that the Constitution prohibits the continued indictment and prosecution of a president is categorical and does not turn on the gravity of the crimes charged, the strength of the government's proof, or the merits of the prosecution. And that, quote, but for Mr. Trump's election and imminent return to the presidency, the office assessed that the admissible evidence was sufficient to obtain and sustain a conviction at trial. In other words, Donald Trump ran for president, like I said, so he wouldn't have to spend the rest of his life in prison. The chairman and other members of this committee have spent all day attacking you and trying to rewrite the history of January 6th. But Mr. Jim Jordan, the chairman, failed to mention how he was running around the Capitol terrified by the possibility that all those insurrectionists would harm him. In fact, on page 97 of the deposition transcript, you mentioned how Mark Meadows, the president's chief of staff, quote unquote, never saw Jim Jordan so scared. The chairman also failed to mention that he was in direct contact with the White House in the days leading up to and on January 6th, which is why his toll records were subpoenaed by your office. Let me be clear, because they're trying to act like this is Democrats on Republicans, and I guess you are a covert Democrat that knew that he was going to try to steal an election before he tried to steal that election, and so therefore you were somehow put into place. I mean, the conspiracy theories make your head spin, but nevertheless, were you going to subpoena the toll records of every single Republican simply because they were a Republican?
No, we subpoenaed the toll records in the course of this investigation because they were relevant to our investigation.
Relevant? Oh, okay. All right, so that means something about facts. So let's talk about facts. Donald Trump lost to Joe Biden, yes or no?
That's correct.
Okay. In fact, 60 federal and state courts have found that there was no evidence of election fraud. Trump's own attorney general and vice president knew that he lost the election, but he still tried to steal the election by pressuring state officials, designing fake elector plans, nearly having Mike Pence hanged, and ultimately demanding that his supporters, quote, fight like hell, correct?
Correct.
We all saw it happen we all saw what happened once they reached the U.S. Capitol. As your report outlines, President Trump knew that he would incite violence at the Capitol that day. In fact, some of Trump's senior advisors were pushing for violence. For example, page 81 of the report details how co-conspirators number 2, John Eastman, tried to convince Mike Pence to break the law, stating that, quote, violence was necessary. So it isn't just Trump who is responsible for the death of multiple law enforcement officers and the injuries of thousands of people. A lot of Republican members of Congress are also responsible. 147 Republicans voted to overturn the 2020 election results, including multiple members currently serving on this committee, and I will yield.
Gentlelady yields. Gentleman from North Carolina is recognized.
If that felt ridiculous, that's intentional. Because you're watching a committee hearing that's supposed to be oversight turn into something else. A reputational protection detail. The vibe is, how dare you investigate us, instead of, did the evidence support what you investigated? And Crockett's point lands because it exposes the tell. They're not litigating Trump's conduct. They're litigating whether the investigation had a stamp on it they approve of. That's why the questions orbit appointments, authority, and technicalities like they're sacred scripture. It's not because procedure doesn't matter. It does. It's because procedure is the easiest shield to hide behind when the substance is radioactive. If you can convince viewers that the investigator is illegitimate, you never have to face the investigation. That's the tactic, and it works because most people don't have time to read the actual legal standards. Here's what wasn't in that clip. First, this entire authorization obsession didn't start today. It's been the dominant defense strategy in post-January 6th accountability fights. Attack jurisdiction, attack legitimacy, attack process. Not because they suddenly became constitutional purists, but because it's a way to make accountability feel like persecution. Second, the clip references multiple categories of evidence and documentation that matter even if you ignore the political theater. A special counsel report with page references, including page 137, deposition testimony with a page reference, page 97, claiming Meadows said he'd never seen Jim Jordan so scared, and toll records subpoenaed because communications were relevant to an investigation. Third, Crockett piles in a long list of allegations about Trump's behavior: due process, court orders, wars without congressional authority, enrichment, shakedowns. Here's the key. Those are argumentative claims used to frame motive, not automatically proven facts just because someone says them in a hearing. The stronger part of her argument is when she stops narrating and starts pinning things to documents. Fourth, the 60 courts and 34 convictions lines are presented as rhetorical anchors to establish this isn't a mystery. Again, in your script you should treat those as claims made during the hearing, unless you've independently verified them. Finally, what's missing is the meta-context. Why Jordan is the face of this. Jordan has been a central media figure in committee confrontations. He understands the incentives: clips, outrage, base signaling, and procedural fog. That's not a conspiracy. That's how these hearings are now designed to function in the social media era. Let's translate the legal mechanics without turning this into a law school lecture. The fight you're watching is about investigative authority and limits on prosecuting a sitting president, plus the legal basis for subpoenas. Special counsels are appointed under Department of Justice regulations, and disputes often come down to whether the appointment fits statutory authority and constitutional structure. In plain English, Congress can create agencies and offices. The executive branch can appoint officials. Courts evaluate whether the appointment and powers are lawful. Congress has investigative power as part of its Article 1 legislative function. Committees issue subpoenas to gather information relevant to potential legislation and oversight. That's why toll records matter. Phone toll records aren't wiretaps. They're metadata. Who called whom, when, and for how long. They can establish timelines and connections without revealing content. Crockett reads from the report claiming the department's view is that the Constitution prohibits indictment prosecution of a sitting president and that the assessment of evidence was sufficient but for election and return to office. This is the core procedural reality that shapes everything. Even if evidence exists, DOJ policy and constitutional interpretation can limit prosecution while a president is in office. So when Crockett says he ran so he wouldn't be prosecuted, that's her political inference from a procedural constraint that does exist in U.S. practice. You don't have to agree with her tone to understand the point. Power changes the legal timeline. And that's exactly why process becomes the battlefield. If you can't win on substance, you win by delaying, disabling, or delegitimizing the mechanism. This isn't about, was your appointment proper? It's about making accountability impossible to finish. Here's the strategy. Notice how quickly the questioning shifts into appointment authority, procedural legitimacy, and technical framing. Not what Trump did, not what was planned, not what communications occurred. That's narrative substitution. Instead of, why did you subpoena toll records? As a legitimate inquiry, it becomes, how dare you subpoena toll records? The goal is to make investigation feel like harassment. When an audience hears unauthorized, they mentally file it under illegitimate, even if they don't know what law applies. That's the point. It's a shortcut that bypasses analysis. Crockett pushes back with a clean, repeatable line. The subpoenas were issued because the records were relevant. That word relevant is doing important work. It recenters the legal standard. And then she twists the knife politically by saying, Jordan didn't mention how scared he was, didn't mention contact with the White House, didn't mention why toll records mattered. Whether you like her style or not, she's highlighting a pattern. People hide what makes them look implicated. The bigger motive is simple. If they can convince the public that investigation rust on partisan weapon, then future investigations become politically toxic before they even start. That's not oversight. That's pre-immunity. Zoom out. When committee hearings become content factories, institutions rot in public, because oversight only works if the rules are consistent. Subpoenas mean something, evidence is evaluated on merit, and witnesses aren't turned into props for viral clips. If the new norm becomes, any investigation into our side is illegitimate, then the system stops being checks and balances and starts being tribe protection. That has consequences for normal people, not just politicians. It means the government becomes less capable of investigating corruption, abuse of power, and coordinated wrongdoing, because every investigation is immediately framed as political, and the public gets trained to reject evidence on reflex. And here's the chilling part. Once you normalize process warfare, you teach future officials the lesson that the law is just a maze, not a boundary. So even if you don't care about Trump, Jordan, or Crockett, you should care about the precedent. Can powerful people disable investigations by discrediting the mechanism itself? Because if the answer becomes yes, then your rights exist only until the powerful decide they're inconvenient. This is like getting caught on security footage and insisting the real crime is that the camera had the wrong brand name. This isn't oversight, it's immunity by procedure. If you found this breakdown useful, hit the like button so more people actually get the context instead of the clip. Drop your thoughts in the comments. I read them, and I want to know what you think. Share this with someone who's only seen the headlines, and click the bell so you don't miss the next one. Thanks for watching, and don't forget to subscribe for more.